Hello, welcome to Eagle's remote CLE, continuing education. I'm Mitch Orpett. I have the privilege of being the chair of the Eagle Network, and I wanted to thank you for being with us today as we present this session on mediation. For those of you who don't know Eagle, we are a network of independent law firms and adjusters, claims-related service providers who are dedicated to providing high-quality legal and claims-related services to the insurance and litigation industries. We tend to be a relationship-based bunch, and a good deal of our work over the years has been in the form of live conferences where we've gotten to meet with you in person and live and share our conferences and our collegiality. We also have a series of publications that we have on our website, which I would recommend to you at eagle-law.com. And today, in the absence of live conferences over the past several months, we are combining our publications and our conferences by Zoom. And we're delighted to be able to offer this new initiative of having on-demand continuing education and training. And as ever, we're going to focus on practical and strategically important topics such as mediation today. So I wanted to give a great thanks to our conference's chair, Lindsay Woodrow, with the Waldeck firm in Minnesota, Wisconsin, and to introduce her and thank her for her services in making this event and others like it possible. Thank you for joining us today. I hope you enjoy the presentation. Lindsay.
Thanks, Mitch. I appreciate that. My name's Lindsay Woodrow. I'm with the Waldeck firm in Minnesota and Wisconsin, as Mitch so kindly introduced me. I think you all know, if you know Eagle, that we put together publications, as again Mitch mentioned, that you can find in our library on the Eagle webpage. We decided this year to try and supplement some of those publications by including in our library these webinars. This is our first one, so let us know how it goes. But we're going to continue to add to the library as we put these publications and these webinars together. So if you go back and check our library webpage, you'll hopefully see some new ones here shortly. If you have any suggestions, I think some of you who have known Eagle for a long time know that a lot of the publications that we put together, we do at the request of some of the clients that we work with. And so if you've got a suggestion for a webinar that you'd like to see, a topic that you would like Eagle to address in this way, certainly reach out to me, reach out to Mitch. We'd be happy to put together a webinar and put it on our website. Finally, and probably most importantly, we say this at all of our seminars, and it is true for our webinars as well. If there is a question that you have after listening to our webinar today, reach out to the Eagle member for your jurisdiction or the one that you're working in and ask them the question. We are always, always, always happy to answer an email or pick up the phone and answer any questions that you guys might have. And we don't need to have a claim open. We don't need to open a file in order to answer those questions. We're just happy to talk to you. We're happy to share information and to give you some good sound legal advice. So please don't hesitate, pick up the phone and give us all a call. With that, I have the honor and privilege to turn this first webinar from Eagle over to Jeff Hill. Jeff is our Eagle member from Oregon and Washington. Jeff, thanks for all of your work in putting this together, and can't wait to see what you guys put up.
Thank you, Lindsay, and thank you everyone for attending our webinar and watching it at your convenience. Today, our topic is mediation, and particularly Zoom mediation, since with the current environment, most of us are not in our offices, most of us are in our homes, and you will see most of the participants today in their homes. So we're talking about mediation and particularly Zoom mediation. Let me introduce our panel. Our first panel member is Ron Dinning. Ron has been a defense lawyer focused on insurance coverage in Seattle for approximately the last 35 years. He began to mediate in 2001 and now focuses exclusively on mediation, primarily in the area of insurance coverage disputes. He's a longtime Washington super lawyer and an honors graduate of the University of Washington School of Law. Ron, thank you for attending.
Thank you, Jeff.
Thank you. Our second participant, the rest of our participants are actually Eagle members, many of whom you have met. So our practice is to introduce them in a little bit more abbreviated fashion because you have all of our information both on our website, but also on the Eagle website. You can find everyone's biography and all of these webinars at eagle-law.com. So our next participant that I want to introduce is Christine Gilliam. Christine's a partner in the Reminger firm that you know is a Midwest firm with offices in Ohio, Indiana, and Kentucky. Christine practices in Louisville, Kentucky, where her focus is primarily on professional liability, long-term care liability, and insurance coverage. Thank you, Christine.
Thank you.
Our next participant is John Egan. John is a partner in Rubin and Rudman in Boston, Massachusetts. John handles products, church liability, fire, professional liability, and insurance coverage type claims, among other legal matters. John, thank you very much.
Thank you.
And finally, our final participant is John Cuttino. John Cuttino is a partner in Gallivan, White, and Boyd in South Carolina. John practices in the Columbia office of Gallivan, White, and Boyd. John handles catastrophic personal injury, professional negligence, and insurance coverage and bad faith claims. John also devotes much of his practice to acting as a mediator. So we have two participants who practice some or all of their practice in mediation, and the rest of us practitioners who have not done a lot of mediation as mediators ourselves. So our structure, as I mentioned, is mediation, of course, and really what we want to focus on is the impact of virtual mediation on mediation itself. But there are some topics, some general mediation topics that we like to address each time we talk about mediation because they tend to change. People have different views, and so we feel like it's worthwhile to discuss some general mediation topics all the time, as well as the Zoom focus that we have today. So first, Ron, let me ask you this. As a mediator, the mediation hasn't started yet. You've been selected as the mediator. Perhaps you know some or all of the lawyers. Perhaps you know some or all of the parties. Can you give us some insight in how you approach a mediation as the mediator? And as part of that, what do you like to learn in advance in written documents that you receive?
So, I think for me, mediating is a lot of personal connection and building relationships, whether it's throughout the day or over repeated mediations with lawyers that you see time and time again, which I'm fortunate doing coverage, mostly work. I see a lot of the same lawyers and we get to know each other. The ones that don't like you, you probably won't hear from them again, but there's a process of natural selection there. Pre-COVID, if I am working with a lawyer that I haven't met before, I'll go to their webpage. I'll try to find something about them in their past that interests me that I can talk to them about. And I generally would arrive on the day of mediation early. I'm sort of roaming around looking for that little personal contact time before we get started. Since mid-March, I can't do that. I've done dozens of mediations by remote video since mid-March and have not done one in-person mediation since then. So I'm using my phone more. If I don't know you and my name's been given out, I want you to call me. I will probably call you before the mediation if you don't. And I want to start just talking to each other and getting a good feel for communication, and also let them explore, competence issues. Since I found when you're doing insurance related mediations, they like mediators that understand coverage. You don't have to educate them. So we'll talk about coverage, right? It doesn't take long to figure out whether or not you sort of get the lingo and have experience with that kind of problem.
Thank you, Ron. John Cuttino, you too as a mediator, what do you like to see from the lawyers in advance of the mediation? What do you like to see in papers generally before we get specific to Zoom mediation?
You know, Jeff, a couple things in terms of if it's any more than just the simplest case, a chronology helps. If there's applicable law, I certainly appreciate that. It just sort of calls my eye and makes me focus on what the lawyers at least think is important. But as much as anything, maybe even more so than the law, I'm always interested in what the emotional battle lines are. For example, if it's a personal injury case, a lot of times there's a lot of emotion caught up in that. I'd like to know where those things lie. If a lawyer will tell me, I will give them the opportunity and would be very interested to know if they are getting along well with their own client, if there are relatives in the picture who have an outsized a voice in the mediation. Those things help me navigate through a situation that I am literally parachuting into. You know, as a mediator, you're stepping into relationships and circumstances that have been developed over a long period of time. So the more I know about the relationships between the people, the problems, the battle lines, the concerns, the emotional baggage, whether the lawyers carry it, whether the litigants carry it, or both, those things are things I will ultimately come across and have to deal with. I would prefer to learn them before we start. That way I can proceed more efficiently and look out for those things as we go through the day.
Thank you, John. Christine, let's step back one step to before we've actually selected the mediator. You handle different kinds of cases. What I'd like to ask you about is your thought process in selecting a mediator. Does it vary by the type of case that you're involved in? Do you listen to the other side? Do you talk to your client? Talk to us about your thoughts about selecting the mediator as driven by the type of case and the people involved.
Sure. Well, I do think that if you have a personal connection with a mediator, like Ron was discussing, those tend to be the mediators that I go towards because they know me, we communicate well. That's who I gravitate towards. But apart from that, certainly if there's a mediator that has a practice in a certain area of law that's relevant to the case, you can't ignore that, right? Like you need to take that into consideration when you're choosing a mediator as well. And then otherwise, I like to source opinions from my colleagues. You know, my firm fortunately has lots of offices and lots of lawyers, and we frequently send out emails to everyone, you know, get their thoughts on this mediator for this type of case. And I like to source experiences from other people before I agree to a certain mediator. And I rarely agree to a mediator that I've not worked with before or not heard of, unless I can find somebody that has worked with them before, because I don't want to waste my time, my client's time, or resources, you know, in getting mediation and having a mediator that's, you know, not, in my opinion, putting forth the best effort.
Thank you. John Egan, would you talk a little bit about that selection of a mediator, but maybe spend a little bit more time talking about your written materials? How do you approach the written materials that you submit to mediators, and who's your audience? Is your audience just the mediator, or are you using it as an opportunity to communicate with somebody else?
Well, in terms of submitting written materials, I take my lead first from the mediator. Mediators have different preferences and requirements, and I'm happy to follow their lead. If they want something that's intended to be circulated among everybody, including my opponent, I'll write a mediation statement with that in mind. If they want something that is not intended to be seen by the other side, I will write, in some cases, a much different kind of memorandum. My principal goal before the mediation starts is to show all my cards to the mediator. I want to be as candid as I can with the mediator, and I want the mediator to be candid with me. And if it's somebody I've worked with in the past, hopefully I've developed a level of confidence about that. But if I have some strengths and some weaknesses that I need to share with the mediator, I want the mediator to know that up front. I also want to be able to be candid with the mediator about what I think my opponent's weaknesses are, whether it's a weakness in the substance of the case or a weakness in the dynamic between the lawyer and his client. Sometimes, as we all know, clients drive this process because of some unrealistic expectations. If I think that's what's an obstacle to settlement, I want the mediator to know that. Sometimes the lawyer can be an obstacle to settlement. My relationship, hopefully, with most of my opponents is a good, productive, civil one, but sometimes the train comes off the tracks. And I want to be able to share information like that with the mediator in candor. If the mediator wants or insists that the written submissions be public, so to speak, available to everybody, then I will at least ask for an opportunity to have a chat on the telephone so that I, off the record, without my opponent present, so that if I'm dealing with a mediator like John or Ron, I can tell them up front in the course of a phone conversation what my concerns are and what I think they need to know in order for the mediation to be successful.
One of the areas that I think generates a lot of different opinion in mediation and varies around the country is the use of face-to-face interaction between parties and their lawyers and other parties, not just having the interaction with the mediator and a party. And I think practices vary around the country, views vary. Ron, what are your thoughts, maybe pre-COVID and then now with Zoom mediation, of the usefulness, the risks of face-to-face meetings among the parties for particular subjects, or at the beginning? Or what are your thoughts on that, Ron?
So my experience is that this varies by region. And in the Pacific Northwest region, where I have done almost all of my mediation work, either as a mediator or as a lawyer, they don't do face-to-face meetings. On those rare occasions where I put parties together at mediations, more often than not, I've lived to regret it. And typically out here, it's just everybody. You don't see anyone except for me all day, although I don't police the hallways and that sort of thing. But I found most of my mediations, unlike when I was a lawyer, where I'd be out roaming the hallways and looking for the other lawyers and seeing what I could learn and do. The lawyers I work with don't generally seek each other out. Sometimes I wonder if they've lost the ability to negotiate for themselves, sometimes younger lawyers, that they rely so heavily on mediators. But we don't do joint sessions. And I want to comment about the submission of papers. Mediation is a voluntary process, and I try to have as few rules as possible. And what I have found, though, is that plaintiffs almost always share their mediation papers universally. Defendants here in our region are about 70-30. I always shared my stuff as a defendant lawyer. And you can always write a second private letter if you want to. But I appreciate it when they share the letters, and I really appreciate John's comments about being candid. When you tell me what's weak about your case, I appreciate it. I appreciate the candor. You gain credibility with me, and I was probably going to figure it out anyway. I do expect you to tell me everything that's wrong with the other side's case, certainly. So I look for that too.
John Cuttino, what's the experience in the Southeast and your views on face-to-face interaction among parties?
Well, in state court and federal court, mediation is mandatory here. It's not a voluntary process. So essentially in every county in South Carolina and every federal court, we have no choice but to mediate at some point. Mediation is by custom, person to face-to-face. We did not start mediating via Zoom or video really until the pandemic. So this has been a huge change for us. It's a cultural change. My experience in the last several months doing this is that much of the success of it depends on the kind of case. If you have a commercial case with a lot of businessmen who are litigants, they view this process as time consuming. They want to get to the point. They seem to be very effective at mediating by Zoom. In personal injury cases, I would suggest to you that the Zoom video conference leaves a little bit to be desired, because there are cases where litigants need to emote, they need to go through the process, they need to be in the presence of people who are paying attention to their issue and acknowledging their loss, acknowledging their position. For some people, that's very psychologically important, and it's important to the process. I honestly don't think you achieve that level of interaction via video. It's not impossible. We've settled a lot of personal injury cases via Zoom, but I do think it takes some of that element away. I can hear the argument that maybe some of that element needs to be taken away, and that video is successful in sort of de-emotionalizing the process, but I'm not sure that's always the best. As a mediator, I also depend a lot on nonverbal cues that people unintentionally give you. When you mediate via Zoom, what you see is what they want you to see on the screen. You know, when the lights come on and they are in front of the camera, that's what you see. You don't, as a mediator, get to see what you may come up on walking around in the hall, on the way to the restroom, on the way to get a cup of coffee. You don't have the bump into someone experience. And those things I have found over time are important. And sometimes they give you information that lets you facilitate the mediation further. So I guess my overall point would be a lot of it depends on the kind of case you are trying to mediate by video.
John Egan, what do you think about face-to-face interaction with the other side, either in the hallway in an old style mediation or in a virtual mediation?
I'm sort of of mixed minds about it. It's increasingly less the case that we have a formal face-to-face session at the beginning of the mediation. When mediation was sort of in its infancy, I think we all got used to a process where each side had 5, 10, 12 minutes, whatever, to make kind of a mini opening statement. And I think we all tired of that fairly quickly. I know the mediators did. So I don't miss that part because I think a lot of the lawyers abused it and we just got off to a very slow start. So that piece, I think, was overrated to begin with, and I think dispensing with that is a good development. Having said that, I think the last mediation I did before everything locked down, whatever it was, 5 or 6 months ago, was a mediation with a mediator that I had not previously used. It was a guy I knew and had heard of, but just by luck of the draw, I had never used him myself. But my opponent was somebody I'd litigated several cases with. And I never saw my opponent at the mediation. He and his clients were kept in a separate room. My clients and I were kept in a separate room, and the mediator went back and forth. We didn't settle the case. I don't know if that was the reason why, but I just thought the whole process had a very artificial feel to it that I think we might have avoided if we had had just a short session in the same room. So we look across the table at one another, introduce ourselves, express some hope that the process will work, express some desire to proceed in good faith. Sometimes you have to show a little empathy. If it's a bad personal injury case or a death case, it's sometimes useful for a defendant to look across the table and say, I'm sorry for your loss. We're not here to diminish or trivialize what you've experienced. And I think that that kind of thing can only happen face to face. So I don't think it's entirely useful to dispense with that altogether. I forget whether it was John or Ron who said it's really a function of the case, but I think it can feel a little stilted to be segregated into separate wings of the building right from the start.
Christine, what's the practice in the Midwest, and how do you usually proceed, and how's it different now in the era of virtual mediations?
Yeah, so in Kentucky where I practice, we typically start with a joint session, but it's short. Like John mentioned, it's introductions, it's ground rules. Typically there's not a substantive opening statement. Every once in a while that happens, often from the plaintiff's attorney. I have not done it in years. I don't think a substantive statement is effective. However, I do think a joint session is important to humanize our interactions, right? And so I can look at the plaintiff in his or her eyes, and they can look in mine and know that I care, know that I'm a person, I'm not this abstract defense counsel enemy, right? I think that goes a long way. So I don't think that they should be dispensed with. I do think that we can still have that to some degree in a virtual scenario, but everybody needs to have their videos on, for one, right? Sometimes people will not turn their video on, and then you can't look them in the eye. And it's a little bit awkward. So it's not perfect virtually. I do think, particularly in a personal injury type case, that being at some point in the same room with the opposing party is important.
Thank you. Ron, okay, on to exclusively virtual mediation. Big picture, what's your most important takeaway so far? What do you think are the most important things that we've learned? What are the mistakes that we have made but aren't making anymore? Give us the big picture of what you've learned and how you proceed in virtual mediation now.
One of the really interesting things that I'm learning right now is that my transition to Zoom mediation was made easier than some of you, because our mediation model out here in the Pacific Northwest already had everyone in separate rooms to begin with. They would come and they'd be in the reception area. They might see each other there, but they'd literally be sent to separate rooms, and they would be there the whole day. So when I start Zoom mediating, I'm traveling from virtual room to virtual room, but the experience is the same, other than the lack of personal contact. I'm pleasantly surprised how well the communication works with the video. You cannot do this by telephone. You have to be able to at least see people's faces and how they're reacting when you talk with them. It's not a super empathy tool. I have another benefit that all of my mediations are generally insurance coverage and property loss related. I very rarely get involved with personal injury. I do get involved with homeowners who've had really bad experiences and been out of their homes for a period of months or even years because of issues with repairs, but that's not at the same level as physical injury claims, I'm sure. I gravitated towards coverage law because defending injury claims was something that didn't suit me personally, and I'm sure as a mediator probably the same is true. And we're not going back. The Liberty Mutual people are not coming from Boston to Seattle like they used to routinely. They'll still come sometimes. The business people, I think, love this. The construction company owners, they hate nothing worse than sitting in one of those conference rooms all day. And when they can come on, when it's their turn to come on and work with you over the video from their office, and then when they're done talking to you, go back and doing what they're normally doing, they're not going to want to come back either. Maybe they will, because we're local and we'll be gathering local, but I think people who travel, their lives are going to change. People who live in Bremerton, which is on the other side of Puget Sound from Seattle, to come to a meeting downtown, they have to get up, get on a ferry, go across the sound. they seem more relaxed to me when they're at home when I meet them, when they haven't had the burden of traveling downtown. So it works. It has pros, it has cons. You know, that you can do document review with screen sharing, but you got to learn how to do it. When I meet with people who've done this before, it's real easy. Yeah, we're going to do Zoom mediation. Got it. When it's your first time, I have to spend a half an hour to explain to you how we're going to do it, who's going to set it up. But I really see this as a sea change that will persist because of the convenience, the cost savings, because people are going to choose that they'd rather participate this way. And since we've done it, we know we can make it work.
Ron, defining success as a resolved case, is the success rate more or less or about the same in Zoom mediation in your experience?
Yeah, I'm not perceiving much difference. It might be that we're probably losing a little bit of the sense of the day. You know, well, since we're talking remotely, can we talk remotely tomorrow? But overall, settled versus not settled, settled quickly versus settled over time, I'm not perceiving a difference. And I've done, you know, I say more than 24 this way now.
Ron, I wonder if, I'm sorry, Jeff, for interrupting for a second, but I wonder if the claims examiner from Boston at Liberty Mutual, who flies 3,000 miles across country to mediate a case in Seattle, has a greater incentive to get on the airplane to come home with a release in hand and to close that last remaining gap just to get the case settled. A greater incentive to do that if he has to travel than if he can participate this way and just say at the end of the day, well, we didn't get it done. We'll wait till another day.
Yeah, I think you're absolutely right. That is potentially an issue. You know, I think that at least in Kentucky, there's an expectation that person with settlement authority is present in person, and it's expected, if not court ordered, in pretty much every mediation. So I'm frequently telling adjusters, yes, you really have to come. I'm sorry, yes, you really have to fly here. And that's been completely eliminated now. And they love it. The adjusters love it because they don't have to travel. But like you mentioned, maybe they don't, you know, maybe they don't have that same incentive because they didn't fly across the country to come to Louisville, Kentucky. You know, they go see the Slugger Museum when they're here, then they go home. But yeah, I mean, it's definitely an issue. At the same time, it's nice to have to be able to spend that money.
I don't see it impacting, you know, the amount. I tell insureds and plaintiffs, I go, the insurance company doesn't send somebody out here with a blank check. I downplay the expectation that there's someone here who can pay whatever amount they feel is appropriate at the end of the day. I tell them that's exactly what's not happening. This claim has been roundtabled within the company. Now, you know, there's exceptions, but it is a general model. I don't want them to believe that as long as we twist the arm of the person in the other room enough, the money will somehow pop out. I mean, it's just insurance companies don't work that way. There's layers of review. You have to sort of work your way through that. The phone call at the end of the day is still the phone call at the end of the day. The person who's getting called, you know, is not on the video screen. That perception hasn't really changed. Also, I want to mention for John, you know, we do have court-ordered mediations here as well. So participation is mandatory, but my view is you can lead the horse to water, but you can't make him drink. And it's the actually getting it done part where I sense it's truly voluntary.
Right.
But, you know, and if the court says we want boots on the ground from Massachusetts, then, you know, they'll be here. There are certainly aggressive plaintiffs attorneys who not only want boots on the ground, but they'll demand a decision maker, and there'll be fights about that. Who's being sent? A representation that someone is coming with full authority, and then a 35-year-old shows up and you're thinking, geez, I'm not sure this is the guy that they were represented was going to come out here. But
Jeff, Go ahead. I'm sorry.
No, please go
No.
ahead.
Jeff, a couple of observations playing off some of these other comments. First of all, in no particular order, the court systems here made allowances during COVID, suggesting that, well, you know, some of these companies have travel bans. Some of the claims reps are not permitted to travel. So it's better to have a video Zoom where they participate by video than not at all. I think that will result in a relaxation, actually, of the a claims person or a representative of the company must physically be present. I think we've had enough success via video that we will loosen some of those demands. I also think it meets the need of the insurer many times to see the plaintiff, because that is oftentimes important. If there's a scar, if there's a credibility issue, the insurer wants to be able to see at some level the litigants. On the issue, I think, Ron, you made a great point about people being more relaxed in their homes. I think that's true. I'm not sure that's necessarily always a good thing, because the formality of being in a law office, which is not their natural habitat, with a bunch of lawyers sitting around, sort of the gravitas of that moment, it gives me a good platform at some point during the day as a mediator to say, if you think this is a little intimidating, wait till you get to court where there's a judge and 12 jurors that you don't know and deputies standing around. That is a much bigger moment. So as an alternative, this is much better. Sometimes I think people need sort of the formality and the pressure of a gathering of a bunch of lawyers to sort of, you know, give them the idea that, hey, court may not be the best alternative for me if I'm a little easily intimidated. In terms of what I have learned, two things, and I'll turn it over to somebody else. Number one, I think preparation is even more important if you're having a video mediation. The things that you send me as a mediator, your documents, condense them. We all have hundreds of documents we could show in a case. That's not effective on video. I think less is more. Highlighting is great. The lawyers who have practiced and know exactly what documents and exactly what they want me to look at and what they want the other side to look at it, I think it's very effective. And I actually think that video lends itself more to demonstrative exhibits than being in a large conference room where we're all looking at the screen. Because we're in that large conference room, we have the option to look at each other, look out the window, but we are all screen oriented these days. And if you've got a document that you think is really important, when it appears on that screen, I observe that everybody sort of locks into it and you really do get to make your point. Another thing that's only, I think, of concern to a mediator, but it was really a surprise to me, is this. The first few mediations I did via Zoom, at the end of the day, I was exhausted. And it's an effort in person, but what I deduced was that everyone else gets to walk around wherever they are, but when I change rooms, I never leave my chair. So hours had passed and the mediator had stayed riveted to the screen because that's where everybody I need to talk to is. I had to learn as a mediator, and maybe you should learn as litigants and lawyers, make time to wander around as you would if you were physically in an office, because it helps burn off a little steam. I have built-in breaks for myself now as a mediator just to walk around and get away from this laptop, because otherwise when I change rooms, all I do is punch a button and I physically don't move. So an unexpected but valuable lesson. I think the success rate, as far as I can tell, is no different via video. A lot of it depends on how prepared people are, but I will tell you, I think people are showing up to video mediations more prepared than they showed up in person.
Let's talk a little bit about the differences of time pressure and pressure of actually being there, virtual versus an actual face-to-face mediation. I admit that I was a little skeptical before my first Zoom mediation, because we all have been in mediations where we sit around and nothing seems to happen until 4 o'clock. And as plane schedules get closer, as people want to go home, then decisions tend to be made more quickly. So I was a little skeptical that a Zoom mediation could create that. And then on the other end, the pressure that comes from when people have places to go or planes to catch, decisions tend to be made. Whereas now we're all in our homes and the tendency is to think, well, we can talk until we run out of things to talk about. Ron, talk a little bit about the difference of the time pressures and presence pressures, mediation virtual versus live.
So I've only had one I recall in particular that ran late. Typically my mediations don't run late. As we know, 4 to 5 is a magic hour on a lot of these things. And stuff tends to get done around then. That still seems to be true. People are still paying attention to that. I don't know if it's because because they're making dinner or the kids are finally completely out of control, at the end of the day. It hasn't really changed pacing for me. And so, yeah, I just, it would seem like it would, but I haven't experienced that. People still want to shut down at 5 o'clock, whether they have to go to the airport or not. And at the same time, nobody has anywhere to go. But we just seem of working. For me, it's been the typical kind of mid to late afternoon is when things are actually getting done.
John Egan, any experiences like that? Any strategies that you've developed that are different in a virtual mediation because of time?
Short answer is no, I don't think so. I don't think my personal database is big enough yet to draw a lot of conclusions. In Boston, we do not have mandatory mediation. It's all voluntary on both the state and federal side. So I think we actually got a slow start. I think we were all willing to start doing depositions this way. And the courts, very shortly after that, were willing to start doing hearings. But I think all of us had this kind of instinctive feel that mediations can't possibly work very well this way. But as this thing dragged on, we realized we can't just put our mediations on ice forever. We've got to try this. So we've started to do it more often, and I've now done, I don't know, probably half a dozen since late spring, early summer. And candidly, they've not been very successful, but I really don't think it has anything to do with the format. I forget who just mentioned it about preparation. I think it is true, at least I know it's true of me, that I feel like I've been more prepared to go to a Zoom mediation than to show up in person. That's not to say that I went in, with a briefcase that I'd never looked at before with a live mediation. But I think there's something about just the dynamic of being in front of a camera and a screen. It feels more like a performance than sitting in a conference room. And I think that's motivated us to be just that extra 10% more prepared, so that we can address anything that comes up during the course of the mediation. The other thing is, I'm doing this from my living room. I'm not in my office. And if a mediator asks me a question in a live mediation, I can always just say, I don't know the answer, but my file is right down the hall. Let me go get the answer for you. I can't do that where I am now. So I've got to make sure I've got everything I need in place before it begins. And I think that should increase the success rate of mediations. Again, I don't think the fact that I haven't had a great run of success of late has anything to do with the format. I think it's more my opponents who are, I'm always the voice of reason in these. It's always my opponent who's driving unreasonable expectations. So I just think it's luck of the draw of late.
Christine, your thoughts on time pressure differences in a virtual mediation versus a face-to-face?
So I think there is an overall premise or idea that there are less time constraints because we're all at home. And I think that isn't necessarily applicable to a lot of us, particularly with young kids at home. While I might be working at home and I don't have a flight to catch at 5 o'clock, there are other things taking off in my house at 5 o'clock that I need to address. So, I think that there are still ways, and they're just as demanding as a flight schedule. So I think there are ways to push resolutions as long as we communicate our availability and not be shy of the fact that just because we're at home doesn't mean we don't have other things that we need to also take care of. So I think there are still ways to push in terms of time, but it sounds like from these experiences that that's not been as much of an issue. John
Cuttino, sometimes it takes some time for a mediation to really click and get going. Is it different? Are there some harder obstacles to get over in a virtual mediation? Is there a risk of an early impasse that's hard to overcome that might not be hard to overcome if the people could see each other walking around?
Jeff, maybe two comments on that. Number one, my experience has actually been that we seem to get to it sooner than we did in person. I don't know whether the opportunity for, the social hour is gone so that we just tend to plunge right in. But my experience is, and this is true whether we do an opening session like's been talked about previously today, or whether we just all, break up and in our separate caucuses and start. I just think we get down to substantive, conversations sooner than we have in the past. As for the end of the day, I have not noticed any change in the afternoon pressure. People's attention span is kind of what it is, and there's a natural decline in impatience and sort of exasperation that starts building up at about 3:45 if we haven't made enough, as much progress as people wanted to think we should have made by that time. So I don't think video makes the day longer or shorter. I do think we start earlier. One curiosity, and I can't calibrate this into anything, but one feature of a video mediation that it's going to sound kind of trite, but I think it's influential. One thing we don't deal with now is, the grand ordering of lunch. Okay. Everyone's free to eat off camera or whatever they want. So we don't have that interlude, which sometimes, is kind of smoking the peace pipe of what do you want for lunch? Pick out something from this menu and we'll have it sent in. Sometimes that is a very natural and necessary break to a tense proceeding. There are those who become nicer after they eat. The temperature of the water sometimes goes down after people eat. Since no one is eating at the same time, I don't think in these video mediations, of course, it's impossible to know. You don't have that. You don't have that component of it, and I think that makes a difference. It's not a terrible negative difference, but there's a difference there.
Ron, we touched on this a little bit. Are you seeing behavior, politeness, willingness to work things out side to side? Is it more or less in a virtual mediation than face-to-face? Are lawyers generally acting better, clients acting better? What do you think?
It's a little looser, and I think everybody is operating under a higher level of stress than they would have been a year ago. And so maybe I sense a little bit of that. You know, I get yelled at from time to time. I've been yelled at recently. I'm just really absorbing the yelling. It's not really directed at me. So yeah, I think maybe lawyers are losing their temper a little quicker than they might have in the past. There's some change in that. And you know, you're dressed less formal. It's a less disciplined atmosphere. Everything is less disciplined.
Jeff, I think I actually have a different, have had a different experience. And maybe it's because on the East Coast, we're such nice people, but I just think, and I think it might be attributable to two things. One is, you know, if you're with a lawyer who tends to be melodramatic and throw temper tantrums and raise his voice and toss his pen down on the table, that feels a little silly when you're sitting in your living room all by yourself, putting on a performance for a screen. So maybe the lawyers who are inclined to do that kind of thing just feel self-conscious enough about doing it in the solitude of their den to not do it as much as they would if it was in person. The other is I think everybody is, I agree, under a lot of stress these days. This is not an easy time, and we're all dealing with it in different ways. And I guess I would like to think that it's improving some aspects of our human nature, and we're just a little more empathetic, a little more forgiving, a little more kind to one another, and because we all know what we're living with, and maybe that's leaking into something as typically adversarial as the practice of law and the engaging in mediations. My experience has been, and I've had some mediations with some really contentious people. Doesn't necessarily mean we've settled the case, but the experience itself, the process of doing the mediation was just fraught with a lot less negative, unnecessary energy than might have otherwise been the case. Just my very short-term experience.
Christine, what's your experience with lawyer and party behavior in virtual versus face-to-face mediations?
You know, I think people are a little bit more humanized because we're at home, we're in a more relaxed environment. We may be dressed down, maybe our kids are running behind us. Like everybody just has a little bit of a glimpse into someone else's life, and it humanizes them in a way that you don't get in the more formal atmosphere. And I think that lends itself to empathy. And so in that way, I think it's a good thing, and people are, maybe under stress, but also more sensitive to the fact that everyone's going through something, whatever it might be right now. Everybody has a different, set of circumstances that they're dealing with, but we're all dealing with something. And I think that's a good thing. I think our profession needs more of that.
Let me ask all three of the EGLE members, John, and Christine, to comment on how, if at all differently, you're preparing your client for the mediation, because probably you're not in the same room together. How, if at all, are you approaching the preparation and the mediation itself in your relationship with your client? Christine?
Yeah, so I think it's similar to when I'm preparing someone for a deposition, I'm preparing them like they would be in trial. And so I'm preparing a person for mediation like they were having a deposition taken, this is a formal process. This is serious. You need to be invested in this, even if you're only going to be, virtually attending or on the phone or whatever it is. This is as important as any in-person mediation. So I think it's just explaining to your client that this process is important, and it can work in this scenario as well. And we need to, all be there 100% and in good faith to try to resolve the case. That's why we're here. And just impressing that upon them, I think is, for me, the most important thing right now.
John Cuttino, how are you approaching talking to your clients, not as a mediator, but as a lawyer going into a virtual mediation?
Well, most all my clients would be either insurer reps or corporate reps of some, company, for the most part. A couple of things that I think are very important. They're more style, but I still think they're very important. You certainly need a prearranged back channel, form of communication, whether that's text or whether that's email, because you don't always want to talk to your client, in full view of the mediator or whoever else you're talking to. So that's very important. The other thing I think is even more important is this. If your client or your rep is not physically with you, they need to be at the ready instantly. Nobody is thrilled that they're not all present to begin with. And so to have to wait to get somebody back on the Zoom, to get your client, to get them off another call and get them back on the Zoom, it's not the best. And I've seen irritation caused by the fact that somebody who was supposed to be, engaged fully that day in my mediation, we had to wait 20 or 30 minutes so that they could, finish something else. That really wasn't the deal. And I think it makes people, it makes everybody else who's involved in the mediation, including the mediator, a little annoyed. And you don't want to have that disadvantage. I think having them always with an eye on the screen, always with an eye on the text, ready to join back in the mediation at any time is really important.
John Egan?
I'm actually finding that at least in the last, say, 60 to 90 days, some of my clients are educating me more than vice versa. I don't mediate a case every day. I don't even mediate a case every week. I might not mediate more than once a month. And in this environment, we certainly haven't been mediating more cases. So you can still count the number of Zoom mediations I've done on the fingers of certainly less than two hands, whereas some of the claims people I'm working with are now starting to really get used to this. And they're getting more comfortable with it. They understand what the ups and downs of it are. And I have found that some of them have given me some very useful advice as to how to conduct these things. I think what initially caused us the most discomfort was just an unfamiliarity with the logistics of how to do a mediation with 5 or 6 talking heads on a screen, a Hollywood Squares kind of thing, and who talks first and what happens when party A goes out and party B comes in. And all of that seemed kind of unworkable at the outset. We've obviously developed it, the protocols to the point where it is now working. And I have just found that my clients don't need to be handheld as much as they did back in, say, April or May, when we were first trying to get used to this. And some of them have had 3 or 4 times as many of these as I have, and they're actually offering me more advice than I might be offering them. So keep your ears open. Sometimes your clients have more experience on some of these things than we do.
As a wrap up, we're getting toward the end of our time. Let me ask each one of you for your 1 or 2 most important tips about Zoom mediation for all of our audience going forward. And Ron, let me start with you.
So here's what I think. The most important thing about mediation from my perspective is bargaining. You have to get the parties to bargain back and forth. It's the exchange of offers that settles the cases, in my view. It's the exchange of offers that reshapes the expectations, particularly usually on the plaintiff or insured side of things. And so whether it's in-person mediation or Zoom mediation, I never try to lose sight of keeping that bargaining going. There are always special circumstances when you can't do traditional, or not, there will be special circumstances when you can't do the traditional back and forth trading of offers. But in my experience, that's what gets the cases settled. And if you can focus, get that going, get the offers exchanged in the way you would normally, then you should have the same results with Zoom mediation that you do with in-person mediation.
Christine, what are your number one, number two thoughts about virtual mediation?
Number one, I think preparation. Number two, being invested in the process, despite the fact that it feels more informal for everyone involved, clients, adjusters, counsel. We need to treat it like the important process that it is.
John Egan, what's your most important takeaway?
Zoom mediation is still mediation. The logistics and the dynamics of it might have felt kind of peculiar and exotic at the outset, increasingly less so, but it's the same thing. And if it's going to be successful, and I think being able to successfully mediate our cases to resolution is going to continue to be a really critical part of our profession, we need to treat Zoom mediation with every bit of serious purpose that we did when we showed up in person in a conference room in a law office. So I think we've worked out the bugs and the discomfort and the unfamiliarity of how to do it in this format. So we can't fall back on that excuse anymore. So we've really got to treat this as the real thing. And I share, I think, everybody's view that this is here to stay. We may not see it 100% of the time like we're doing now, but it's not going away. We're going to be mediating cases remotely, even once this pandemic passes.
John Cuttino, let me let you have the last word on important tips about virtual mediation.
I'll give you two. I cannot stress enough how much preparation is even more important. I think for whatever obstacles we perceive may come along with a video mediation, those can be counterweighted, if not overcome, by an extra 10 to 20% preparation. So I'd go into these, and I personally as a lawyer try to go into these mediations 10 to 25% more prepared than I would have been otherwise. The other thing is this, and this may surprise you. Keep practicing at this. You would be surprised at the number of lawyers that continue, and good lawyers that continue to show up with a sort of an informal, unprofessional background, dressed down. I still think that your presentation of yourself, of your environment in a video mediation still carries some weight. There are tutorials that you can see on Google about your background, camera angle, distance from the camera. All those things are some of the subtleties that convey an impression of authority, an impression of knowledge, of professionalism that I think count. And I don't think they are just silly, surface level kind of things. I think if, you know, we all want to be taken seriously as lawyers. And so I think it's incumbent on us and our clients to portray that image via video as much as we possibly can. So keep practicing and get good at this. Everybody gets better the more they do it.
Thank you, John, and thank you, all of you. Ron Dinning in Seattle, Christine Gilliam in Kentucky, John Egan in Boston, John Cuttino in South Carolina. Thank you again for a very interesting discussion about mediation in general and Zoom mediation in particular. Mitch Orpett, take it away.
Thank you very much, Jeff, and to your panel. I thought that was a fascinating discussion. And I was not like the bad client who went away, so I actually did listen to everything you folks had to say, and I found it very, very helpful. A lot of good information there. And taking off from John Cuttino's last point, we know that change is inevitable. in this business, and a lot of people have been talking about the pandemic as a force that has accelerated change into a very compressed short period of time. And it's really Eagle's goal to help its members and its guests, its clients, deal with those sorts of changes. And what's going on in mediation is certainly one of them. But there's really a lot. The practice of law and the practice of claims and how claims are handled are definitely undergoing severe change now and will continue to do so. One of the things that we understand, or that people have come to understand, is that one of the traits of good lawyers is to be good listeners. So we too in Eagle want to be good listeners. We intend to supplement this on-demand continuing education with more seminars like this, as Lindsay and Jeff both said. But we want to listen to you. So if you do have ideas, please let us know. You can get our contact information through your handy member brochures or on the website again at eagle-law.com. So check in the website on a regular basis, look for new on-demand programs, new webinars, and we wish you, thank you, I should say, for joining us today. And we definitely look forward to the day when we get together in person again. But thanks very much for joining. Thanks again to Jeff and your panel, and Lindsay for helping organize. Take care.
Well, thank you all very much. I think that went, I was very pleased with it. Thank you.
Yeah, good job, everybody.